right, thank you. Good morning. Can everybody hear me okay? Good. Well, thank you so much to FIU and to the New York Times for sponsoring this. We're happy to come out and speak a little bit about the work that we do and some of the topics that we're seeing in immigration, maybe debunk some of the myths or explain some of the things that you're seeing in the news right now. If you have any questions, please feel free to ask them throughout, but we'll also have time at the end too if you have any questions, that's something that wasn't covered in the presentation or something about the presentation. So just to get started, a little bit more of an introduction about who I am and who I work for. Americans for Immigrant Justice, AI Justice, is a nonprofit organization dedicated to protecting and promoting the basic human rights of all immigrants. So essentially we're a nonprofit law firm, and what we do is pro bono legal services, provide pro bono legal representation to immigrants in proceedings. Or in affirmative applications as well. So we do kind of a broad spectrum of representation. We're focused, again, since we're pro bono, we focus on low-income individuals who can't afford private representation before the U.S. Citizenship and Immigration Services for affirmative applications, before the immigration court for people who are in removal proceedings. If clients lost either with us or with another attorney at the immigration court, then we also handle the appeal up to the Board of Immigration Appeals. And in certain circumstances, we also handle litigation before the 11th Circuit Court of Appeals for appeals on immigration cases as well. And I'll delve into some of those different agencies in a little bit here. We're also very involved in advocacy at the local, state, and national level in various ways, trying to respond to media requests, explaining some of the things that we're seeing happening on the ground or some of the impacts that different policies are having on our clients. Sometimes we get involved in national litigation as well, if there's clients that may be applicable to. Kind of across the board, we have also put together a couple of investigative reports, particularly on family separation a few months ago, to try to explain some of the things that we were seeing happening. We have 5 different programs at AI Justice. We have the Lucha program, which focuses on representation for victims of domestic violence, sexual assault, or human trafficking. We have the Children's Legal Program, which provides representation to children who are in immigration proceedings. We have the Detention Program, which provides representation for immigration proceedings or also for bond cases or parole requests for immigrants or people who are detained. We have the litigation program as well. They've been mostly doing habeas claims or for children who are currently being detained and are about to age out. They're about to turn 18 and be placed into adult detention centers. We've been focusing on taking those cases to try to find them a sponsor to get them out of detention before they've been moved to an adult detention facility. And we have the Family Defense Program, which is where I work. We do a lot of representation. A big part of every week of what I do is direct representation in various types of cases, but we're also a program that's really focused on this community outreach, trying to go out into the community and explain some of the things that we're seeing happening, explaining what impacts a lot of the policy changes are happening, and doing Know Your Rights presentations to people in the community as well to explain what constitutional rights people have here in the United States regardless of their citizenship status. So kind of jumping into a little bit of an Immigration 101, all of the different agencies that are involved in immigration, the different federal agencies that have a say in that. So the main agency, the main department that's involved in immigration enforcement is the Department of Homeland Security, DHS. And within DHS, there's 3 sub-agencies that have different areas of enforcement or different areas of responsibility. So again, there's Citizenship and Immigration Services, USCIS. They handle immigration benefits, so essentially people who are applying for something affirmatively, some kind of affirmative family petition, or if they're eligible for a work permit, CIS is the agency that processes those applications. There's Immigration and Customs Enforcement, ICE. So they are essentially responsible for the interior enforcement of immigration laws within the boundaries of the United States. So a lot of the detention facilities that you see here, either directly run by ICE or contracted out to a private organization or private company, or in some cases also contracted with local jails, local law enforcement, local sheriff's offices having detained individuals there as well. And the other agency is Custom and Border Protection, CBP. Within that, there's Border Patrol, and then the customs officers that you see at any port of entry coming into the United States. That's all under Custom and Border Protection. So they're responsible for immigration enforcement at U.S. borders and up to 100 miles into the interior of the United States as well. There's a couple of side agencies as well. So obviously the Department of Homeland Security is under the executive branch of the US government. There's also the Department of State. They handle all of the petitions, all of the visa applications outside of the United States. So for example, someone from another country is applying for a tourist visa. That's something the Department of State would handle at one of their consulates abroad. And the Office of Refugee Resettlement, ORR, which is under the Department of Health and Human Services, they're also involved in immigration because they're the ones that are in charge of detaining or housing undocumented children as well, people who are under the age of 18 and here in the United States. They're in charge of the housing or the detention facilities and in charge of finding them sponsors or trying to get them connected to a sponsor to get them out of a detention center. Another agency that's involved as well is the Department of Justice. So when we talk about deportation proceedings, removal proceedings, people who are in immigration proceedings, those are all taking place before the immigration court, which is not part of Article 3. It's not, a judicial court under the judiciary, nor is it an Article 1 court created by the legislature, like tax court or bankruptcy court. Those are all separate courts also under Article 1. This is actually an immigration court that's housed entirely under the Department of Justice, under the executive branch as well. So immigration judges are actually employees of the Department of Justice. So when those immigration proceedings take place then, the two parties that are before the immigration judge is the counsel representing the government, which is an attorney of Immigration and Customs Enforcement. They're the counsel that's trying to enforce removal proceedings, trying to remove someone from the United States. The other party then is the non-citizen, the person who's in immigration proceedings. Because immigration proceedings are civil proceedings, I think that's something that maybe a lot of people don't understand. They're technically civil proceedings, they're not criminal proceedings. So that means that a non-citizen can have an attorney. They have the right to be represented by counsel, but unlike criminal proceedings, they do not have the right to have counsel provided to them. So that means that a lot of people, a lot of non-citizens who are facing removal from the United States don't have an attorney, especially in the detained context, especially immigrants or non-citizens who are detained and trying to fight their removal proceedings. It's significantly harder for them to find representation as well because those cases tend to move more quickly and because the detention facilities are often in rural locations, so attorneys have a lot of travel time just to get there. It's hard for them to get documents and even just find an attorney to come and represent them. That's one of the main things that we see here, and one of the focus is to then provide that pro bono counsel to people in these immigration proceedings who otherwise would not have an attorney and would be going through the process themselves alone. So I'd like to talk a little bit about now some of the different types of immigration statuses. I think we hear a lot of terminology, and I want to kind of run through and explain a little bit more about what these different statuses are. So first of all, you have a U.S. citizen. Right? So that's someone who was born in the United States, was born as a U.S. citizen, or someone who's naturalized, gone through the process, become a resident, and then applied for citizenship and took the oath and were sworn in as U.S. citizens. Then there's a lawful permanent resident, which is also sometimes referred to as an LPR or more colloquially as a green card holder. So if you hear someone who has a green card or is a green card holder, that's also a lawful permanent resident. You have a temporary non-immigrant, so the most well-known of that is a tourist, and they're called non-immigrants because they're people who are here in the United States, but they don't have the intention to remain here permanently. They don't want to come here, they just want to come into the United States for a short period of time for one reason or another, and then their intent is to return to their country of origin. There's a couple of other different types of temporary status, which I'll talk a little bit more about later on. TPS, temporary protected status, or deferred action. One type of deferred action is DACA, deferred action for childhood arrivals. Those are both two types of statuses that do not lead to a green card. People who have those kind of statuses cannot apply for a green card and cannot then later on apply for citizenship. Those are temporary statuses that they need to renew between 6 months to 2 years, depending on the situation. And then there's an undocumented immigrant. So we hear a lot, sometimes people refer to people as illegals or illegal aliens, whatever the case may be. The terminology we use that we think is more appropriate is undocumented immigrant because, again, there's kind of a misnomer there. The act of being present in the United States without status, without papers, is not a criminal violation. There's no criminal law that's violated by that act of being here without status. So that's why it's kind of a misnomer to say these people are illegal because they're not actually, the act of being present in the United States without status is not in violation of any criminal law. So let's delve into that a little bit more then. What does it actually mean to be undocumented? It's a person who is present in the United States without lawful immigration status or without proof of lawful status. So one of the most common things we see is one who entered the United States, a person who entered the United States on some type of visa, any kind of visa that allowed them to lawfully enter into the United States, but then they stayed here after the expiration of that visa. That person would then, after the expiration of their visa or their lawful stay, would be undocumented. You have a person who crossed the U.S. border without detection. So let's divvy this out a little bit more. The act of crossing the U.S. border without going through a port of entry, not going through Customs and Border Protection, that is a criminal misdemeanor, that act of crossing the border without going through an inspection and admittance process. But that's different from someone who's here in the United States without status. That act itself is not in violation of any criminal law. So again, you're seeing someone who lawfully entered in that case and then has no status. There's no criminal law that's violated. Another type of person then, one who obtained lawful immigration status and subsequently lost his or her status. There's actually a lot of ways that people can lose their status here in the United States. That person then at that point, once they've lost their status, they're present here in the United States and are considered undocumented at that point. And then there's one who obtained lawful immigration status but does not have proof of that status. So for example, a green card holder who lost their green card. They would also technically be undocumented because they are a resident. Their residency hasn't been taken away, but they don't have any proof of that because their green card was lost while they're waiting for another green card, for example. So there's a lot of different things that are kind of housed under that terminology of undocumented here, and I think it's important to kind of understand what we actually mean when we're talking about a person who's undocumented. There's a lot of different ways that can happen. So what are some of the types of relief that people have here? Maybe how they entered or the reason they're coming to the United States or after they've been here. There's several different ways that someone can try to gain relief to remain here in the United States in lawful status. And there's two different types of lawful status here. Again, there's immigrant versus non-immigrant. Immigrant, someone who wants to come here and live in the United States permanently, and non-immigrant, someone who wants to come into the United States for a specific purpose, just for a short period of time, and then return to their home country. One of the most common types of immigrant status is family-based, so someone who has a U.S. citizen or a lawful permanent resident family member who then petitions for them. That would be a family-based type of immigrant status. There's humanitarian, the most common of which is asylee, refugee, is one of the ones that people think of the most when they think of a humanitarian type of relief. But there's also various kinds of victim-based relief, which is explained a little bit more in that chart there on the side. The T visa is for victims of trafficking in the United States who assists law enforcement in the investigation of that trafficking situation. There's VAWA under the Violence Against Women Act for victims of domestic violence, either by a legal spouse or a parent or a child who is a U.S. citizen or a lawful permanent resident. There's a U visa for victims of crime here in the United States. They were a victim of a qualifying crime here in the United States. Again, reported that crime to police, cooperated with police in the investigation, and they suffered some harm as a result, either mental, physical, emotional harm as a result of being a victim of that crime. Continued presence is also for victims of trafficking. We don't see that very often. And then special immigrant juvenile status is another type of humanitarian relief for children in the United States, undocumented or in other way documented children who have been abused, abandoned, or neglected by one or both of their parents. That's a type of relief specific to that individual case. There's also a lot of employment-based immigration forms of relief. I won't talk too much about that because we focus mostly on family and humanitarian, so I don't want to give out any incorrect information about that. But there's a lot of different ways in employment circumstances as well where someone can qualify for an immigrant visa and permission to be a lawful immigrant here in the U.S. Some of the non-immigrant types of relief then, student visas are very common. Someone who just come in to obtain a specific degree or to study for a limited period of time. DACA and TPS, as I mentioned before, those are both technically non-immigrant visas because it's not possible to gain lawful permanent resident or citizenship on that type of status. And there's also several types of employment-based non-immigrant visas as well. So I think the most important thing, that was just kind of a quick rundown of most of the types of immigration relief here that are available to people in the United States. But the most important part of that, I think, is that there's not just a general line. You know, sometimes you hear people make the argument people should just come and wait their turn. They should wait in line to be able to come into the United States. there are actually very limited, very restricted circumstances when someone is even eligible to come into the United States lawfully. There isn't just one general line where someone can get in and wait their turn to come in. They need to qualify under one of these various types of relief. So there are a lot of people who actually wouldn't be eligible for some kind of lawful status here who would still like to come to the United States. I think it's also important to note that the waiting period on a lot of types of these forms of relief can be exceedingly long. Because of statutory caps on the number of visas that can be offered under some of these types of relief. For example, the U visa right now is taking upwards of 10 years in some cases for someone to become a lawful permanent resident based on a U visa. I just double checked this morning on a family-based type of relief for because of statutory caps on the relationship as well as sometimes the country of origin. The longest waiting period right now is 23 years for some relatives of U.S. citizens or lawful permanent residents to be able to come here to the United States. So there's a lot of other qualifications and in many cases long waiting periods for someone to come into the United States lawfully. Another important factor to remember, and this is one of the things that the Family Defense Program focuses on in our community outreach, is that undocumented immigrants do have rights here in the United States. There's a lot of constitutional rights that are applicable and available for people here in the United States, people physically present in the United States, regardless of their status, their legal status here. They have the right to trial and the right to court-appointed counsel in criminal proceedings again, not in immigration proceedings. They have the right to due process and equal protection. They have the right against unlawful searches and to refuse searches of their homes without a valid judicial warrant. They have the right to remain silent and not share information that could potentially do them harm. And they have the right to public education in the K through 12 context as well. One of the main differences and one of the most important differences then is that only U.S. citizens are able to vote in local and state elections for the most part and in presidential elections specifically. And that's not even a lawful permanent residence. That is a very particular right that's limited to U.S. citizens. So now moving into a lot of the recent policy changes. There are quite a few, and I'm going to try to run through a few of them, but if you have any questions or are interested in learning more about them, or if there's another one that I don't mention, feel free to ask about it and I'll share the information that I know. So one of the main things was some of the first policy changes that went into effect within President Trump's first week in office were 2 executive orders that he signed on January 25th, 2017. The first one was enhancing public safety in the interior of the United States. And that essentially changed the enforcement priorities. Who was going to be a priority for being placed in removal proceedings? Previously, under the Obama administration, I have that here on the next slide, it was mostly focused on people who had criminal convictions, some kind of significant criminal conviction, or recent entries, or people who are recently ordered removed after January 1st, 2014. Now the new priorities are essentially, as I said, universalized. It's anyone who initially entered without documents, anyone who has a final order of removal, anyone who has been charged with any criminal offense, or who has committed acts that constitute a chargeable offense as well. And this covers far, far greater number of people. In one of the local detention centers, we're seeing many people who had nothing more than were pulled over for driving without a license, and they're detained and then placed into removal proceedings. And that's a big change from what we were seeing previously under the past administration. This executive order also started to put forward punishments for different kinds of sanctuary jurisdictions, and I can talk a little bit more about that, particularly regarding Florida's SB 168, if anybody's heard of that. It increased the number of ICE agents and revived a secure communities program, which increased information sharing between local law enforcement and federal law enforcement, and also increased the use of ICE detainers. Detainers are when, again, someone is pulled over for driving without a license or pulled over for a DUI or taken into custody by local law enforcement for one reason or another. Their information pops up in ICE's system then, and they do a check. And ICE thinks that there may be a reason or that person may be here without status and be eligible to be placed in removal proceedings for being without status or for another reason. And that local law enforcement agency then continues to detain that person beyond the period of time that they would have normally let them go for whatever reason they were pulled over and arrested in the first place. Again, if they would be let go within a few hours for being pulled over with driving without a license or something, then that local law enforcement agency would continue to detain that person for up to 48 additional hours, giving ICE time to come and pick that person up and then place them into immigration detention. That's what a detainer is, and that's essentially what a sanctuary jurisdiction was as well. Jurisdictions who said we will not honor those detainer requests when we have finished detaining a person or processing a person for whatever reason we detain that person to begin with, we're going to release them regardless of an ICE detainer request. And just to go a little bit more locally here, at this point Miami-Dade County is not participating in secure communities, which is that enhanced information sharing, but they have stated shortly after the Trump administration came into office that they will now honor the ICE detainers and detain people for up to 48 hours. The second executive order was border security and immigration enforcement improvements. Had some language about the border wall, which we're still hearing a lot about, some back and forth at the federal level about funding that's available to build more of the border wall. Expanded detention at the border and the expansion of expedited removal. So you can see this map here. As I said earlier, Customs and Border Protection, CBP's authority is at the border of the United States, but it does actually extend up to 100 miles into the interior of the United States as well. So this map, actually, the orange line there, shows up to 100 miles into the US border. You can see that covers the entire state of Florida as well. So the entire state of Florida is subject to both ICE enforcement, interior immigration enforcement, and enforcement by Customs and Border Protection. And one of the main things about that then is this expansion of expedited removal. Expedited removal has long been in effect. Under the Trump administration, it was anyone who was an individual who could not prove to the satisfaction of the officer that they'd been physically present for 14 days in the United States, and they were found within that 100 miles of a land or sea border. They could then be subject to a summary removal without the opportunity to apply for any kind of relief or go before an immigration judge. The executive order expanded that up to, instead of 14 days physical presence here in the United States, up to 2 years. That actually only recently went into effect, and at this point we're being told that that isn't actually, the 2-year expansion of that hasn't really been going into effect too much. But again, because people they don't have access to counsel, they don't go before a judge, they can be removed fairly quickly from the United States, it's kind of hard for us to be able to track exactly how much this is being enforced. This executive order also increased the number of CBP agents and also expanded 287G agreements. These are agreements where local law enforcement, your local sheriff's office, your local police, go through some training with Immigration and Customs Enforcement with ICE, and they are then actually deputized as an ICE agent. So while they are on their local law enforcement duties, enforcing their local criminal laws, they can also enforce immigration laws as well and detain people in those proceedings. So there's been an expansion of that type of agreement and other similar types of agreements that are a little bit more limited in scope. So let's talk a little bit more about TPS and DACA. That's something that's really been in the news a lot recently and previously under the Trump administration. DACA, Deferred Action for Childhood Arrivals, that was started by an executive order by President Obama in 2012. Shortly after coming into office, the Trump administration terminated DACA, allowed people the chance, 1 month period of time to try to renew their DACA status, and then after that no more renewals would be allowed, and essentially DACA would then be phased out. Litigation happened. The Trump administration was sued for the way that it terminated DACA, and that litigation is still ongoing at this point, and federal courts have they have stayed the enforcement of the termination of DACA at this point in time, but not only to a limited extent. So at this time, anyone who previously had DACA status, when their status is about to expire, they do have the ability to reapply and extend their DACA status while this litigation is ongoing. But anybody who previously wasn't eligible for DACA because they were too young, for example, there's many people who didn't have DACA previously and would now be eligible, they are not able to apply for DACA for the first time. Any new applications, those are not being accepted at this point. The other thing is advanced parole travel. So someone who has DACA could request permission and advanced parole to be able to leave the United States and travel internationally. That has also, that was not affected by the injunction either. So at this point in time, people who have DACA are not able to travel outside of the United States. If they do, their DACA status would be canceled. The Supreme Court has agreed to hear oral arguments on this litigation, and the oral arguments right now are set for November 12th. So people are paying close attention to when those oral arguments will happen, and we'll see, generally speaking, the Supreme Court decisions come out in the following June, but we'll see what they do with that. This could drastically change DACA status, so we're watching it very closely to see what they decide. The other main program that's been in the news a lot is temporary protected status, TPS. Temporary protected status was started by Congress, essentially stating people who are in the United States but are nationals or citizens of another country, if their home country suffers some kind of natural disaster or civil strife, or a hurricane, an earthquake, a civil war, the outbreak of a civil war, those people who are present in the United States on the date of the decision to grant temporary protected status have this status and can renew this status every 6 to 18 months depending on the administration, and remain here lawfully, with the idea that their home country is not able to repatriate them because of the issue that they're having in their home country, the natural disaster, some other kind of civil strife. So even though that was technically created by Congress, it is under the authority of the executive branch. The Department of Homeland Security decides what countries should qualify, when to initially grant temporary protected status, and how long to extend it. So another main thing that the Trump administration, when it came in, was to decide that many of the countries who'd had temporary protected status, some for an extended period of time, for many years, some of them did, that those countries were now had sufficiently recovered from whatever issue they were having that allowed them to be granted temporary protected status to begin with. So the Trump administration said, we're no longer going to continue extending temporary protected status. The administration was sued for that as well, and at this point in time, many federal courts have also enjoined or stayed the termination of temporary protected status while that litigation is ongoing. So at this point, most of the countries that the Trump administration has had previously stated they were going to terminate, they do have status through January 2020 or in some circumstances later. But this is also causing a lot of confusion because previously people would renew, they would get new documents, they would get a new work permit that showed an extension into the future. At this point, many of the countries, their work permits or their documents show that they already expired. And the only thing that they have then is a Federal Register notice from the government stating that someone with this particular category or this particular status from this country, it actually is terminated, it's actually extended to this date. And that's caused a lot of confusion for people then because they look at their documents that they're used to having and they may already be expired. So this is something that we're tracking closely, and the administration has announced that they will continue to extend TPS and while litigation is ongoing. So we're expecting that they'll make another announcement, hopefully sometime in December. Here's a laundry list of some other policy changes. I'll go through a couple of them quickly, as they may be things that you've seen in the news or have questions about. Family separation and zero tolerance was in the news a lot several months ago. We are still seeing that it is ongoing. We are still seeing some children separated from parents in some limited circumstances, so it's something that various national organizations and nonprofits are tracking closely. That was essentially started out because of a zero tolerance policy related to the enforcement of that criminal misdemeanor. So as I stated, that there is actually it is actually a criminal misdemeanor to cross the border of the United States without inspection. That previously wasn't really enforced very often because it wasn't really worth the resources in the government's opinion in many cases to actually enforce that. But under Attorney General Jeff Sessions, they did decide there would be this zero tolerance for this type of misdemeanor, and we saw many parents who crossed and brought their children across the border then were transferred to criminal custody, and sometimes 70 or 80 people at one time would be charged and found guilty of this criminal misdemeanor while they were in criminal custody, and then they'd be transferred back to immigration custody to continue forward with their immigration case. But because the children weren't charged with that criminal misdemeanor, and because they then couldn't be detained in criminal custody, the children in those cases were separated from their parents and sent into ORR custody under the Department of Health and Human Services. So that's actually what really happened. That's the reason why family separation started occurring. It was because of that decision to start enforcing that criminal misdemeanor. And many times, as I said, there were sometimes 70 or 80 people at one time were being found guilty of that. Most of the time the sentence, as far as I know, was time served, and then they would be transferred back to immigration custody at that point. Some of the asylum policies we've seen have been also big changes. So there's the Remain in Mexico policy. Basically, people coming from the Northern Triangle countries, Guatemala, El Salvador, Honduras, or really any other countries besides Mexico, they would be allowed to enter at one point into the United States to request asylum, and then they'd be sent back to Mexico until they actually had their court hearing. That caused a lot of confusion too at some point because there may not have been a stable address. So if the court hearing was changed, people would still have an old document saying they had a court date on this particular time. They would try to enter into the United States for that court hearing, and in some cases then they were concerned about whether or not their court hearing had been changed, and now they're not there on the right date. So that caused a lot of confusion as well, but that process is still ongoing at this point. Several thousand people, many thousands of people, are currently in Mexico awaiting their immigration court hearings here in the United States. A recent policy also has been that anyone who traveled through a third country before coming to the United States and they did not request asylum in that third country are not able to request asylum in the United States then. So someone coming from, again, Northern Triangle countries, if they crossed through Mexico and didn't request asylum in Mexico, then they would be ineligible to request asylum here in the United States. The government is making the argument that they should have requested asylum first in Mexico, and if they were denied, then they'd be able to request asylum in the United States. That is a very drastic policy change. That was never something that was happening before. People had the right to request asylum in a country that they deemed to be safe. And this is also ongoing litigation, but the court has decided not to stay the enforcement of that case either at this point. There's been a lot of attorney general decisions that have changed the processing in immigration court. So as I said, because immigration judges are actually employees of the Department of Justice, the attorney general can assign cases to himself, Attorney General Sessions and continuing under Attorney General Barr, changing a lot of the qualifications, when a continuance could be granted, when a judge had an authority to terminate a case or administratively close a case, or in some cases changing what are considered to be sufficient bases for asylum. There's been a call then, because of these attorney general decisions, because of some of the changes in terms of how immigration judges are evaluated, in terms of their employee performance, there's been a call for an independent immigration court to become an Article I court, like a bankruptcy court or tax court. But at this period in time, that's still just in talks. We haven't seen any movement on that in Congress at this point. A huge policy change that you may have heard a little bit about, public charge. Again, another policy that's in ongoing litigation. The Trump administration is essentially trying to limit the circumstances when a person would be considered admissible based on their income or their projected income into the future. So there is a type of inadmissibility, meaning a person is not admissible, not able to enter the United States. That's called a public charge. Previously it was if there were certain factors that the government found that they would be primarily reliant on public benefits of one kind or another, they would be considered to be a public charge and would be inadmissible to the United States. So the definition now of what is a public charge has been expanded greatly. It's expanded to prior use of any other immigration or any other benefits like welfare or other cash assistance and that kind of thing. That's not the part that's the most concerning actually, but that's the part that has had the biggest chilling effect. Since the use of prior benefits should only impact the immigrant themselves, most immigrants or people applying for residency aren't eligible for a lot of government benefits. So that's actually fairly limited. But there's been a lot of concern about that in terms of whether family members or their U.S. citizen children are using some of those family benefits. There's been a lot of confusion, a lot of anxiety among families about whether or not they should withdraw their children from a lot of those public programs because it might negatively affect themselves to be able to become residents here in the United States. But the
question about that.
Sure.
In the case, for example, that refugees, when refugees come, they're allowed to access some benefits. Will the public charge affect them that legally, these are immigrants that legally they can, for a short period of time, access benefits? Is this public charge now like affecting them as well?
That's a really good question. There are a lot of types of status. As I said earlier, many types of people who are applying for residency aren't eligible for benefits, but there are certain types that are eligible for benefits, like asylees or certain types of parole. They are actually completely exempt from public charge. So this ruling of public charge and admissibility, it doesn't even apply to them. So it doesn't actually affect them, and it doesn't affect people who are already residents and applying for citizenship. But again, that's been kind of the confusion. Even people, if they were eligible for these benefits, they may be exempt from the ruling altogether. People who are green card holders applying for citizenship, then now they're confused as well about whether this will affect them. But no, that's a really good question. There are certain types of status that is just exempt from public charge altogether. But the other issue that we're seeing mainly with this too is there's a lot of other factors now that are included in terms of who's a public charge: their age, their health, their family status, their employability skills, including whether or not they can speak English or what their level of education is. And it's been changed to more of a balancing factor. There's positive and negative factors and whatnot. And our concern is mainly, one, is the confusion about what this actually means and who it affects. And then two, it's made it a lot more discretionary. So for whatever reason, it gives the government a lot more leeway to maybe deny someone on this public charge basis. The travel ban at the beginning of the Trump administration was litigated several times, but the third version of that has gone into effect. There's denaturalization. We're seeing a lot of cases where the government is going back and looking at people who are already granted citizenship and looking through their cases again to see if maybe there was some kind of fraud or misinformation done at that point in time, or whether they weren't actually eligible to become citizens at that point. We're seeing a lot of changes with USCIS. So as I mentioned earlier, USCIS is that agency that processes affirmative petitions, work permits, and whatnot. It's more the processing of benefits. And the other two agencies are more focused on the enforcement. USCIS now is taking some steps to become a little bit more of an enforcement agency as well. If cases are denied for one reason or another, for lack of evidence, for failure to respond to a request for more documents or whatnot, they do have the authority now to place someone into removal proceedings, which previously they wouldn't have done, and you would have there wouldn't have been that negative consequence. So it's heightened the risk, essentially, of trying to apply for something, those kind of borderline cases where, we would look at this and say you may be eligible for a U visa based on what you suffered or whatnot, but it's a little bit less clear. There's a little bit higher risk now in terms of applying and placing yourself on the radar in that case. Sanctuary cities, as I said, detainer policies and SB 168 has gone into effect now here in Florida. That was essentially a legislation to state that no jurisdiction, no local jurisdiction in the state of Florida can be a sanctuary jurisdiction, that they need to use their best efforts to cooperate with immigration enforcement and to comply with immigration detainers. In that sense, that's been very controversial, and there was litigation on that as well. But most recently, it has not been enjoined and is in effect now here in the state of Florida. That is limited to, again, people that have some kind of contact with local law enforcement. It's limited to those detained circumstances as well. The 2020 census question, there was a lot in the news about how the Census Bureau was trying to add a citizenship question to the 2020 census, and there was a lot of concern that might make people unwilling to respond to the census and therefore make the census information less accurate. The Supreme Court did now say that the census cannot add that question to the 2020 census, so that is something that's in effect at this point in time, and that question won't be on the next census. We're seeing extensive backlogs at the asylum office, people who are in the United States and applied affirmatively for asylum. There's people who applied back in 2014, 2015, sometimes earlier, and still haven't had their interview. So they're able to be here, and because they have an application pending, they can renew their work permit, but we're really not sure, even some of those older cases, when they'll even have an interview, when their case will be decided. So a lot of people are kind of feel like they're stuck in a bit of a limbo. They want to move forward with their case, but because of backlogs, they're not able to. The raids by Immigration and Customs Enforcement, particularly at Workplace back in Mississippi a couple of months ago, that's an ongoing concern, and that's something that's been happening for many years. And more personally speaking too, notario fraud, especially in this environment, there's a lot of fear a lot of anxiety, a lot of uncertainty. So we're seeing more and more often notarios, or so notary publics, paralegals, or simply attorneys who are not familiar with the practice of law, who are committing fraud by saying, going through cases and saying, look, talking to a person, you have a great case, you're going to win your case, just pay me $5,000, we'll file this application and whatnot. And either not filing anything, which in my opinion is the better scenario, that you're defrauded out of several $1,000s and nothing's actually filed, or in some cases actually filing something fraudulent on behalf of that person, which then extremely complicates their case, because now they have a fraudulent application, or previously they were under the radar, now they're no longer under the radar. So that's something, as an immigration attorney myself, it's something that's really difficult to see, and when we see people who have been victims of that kind of fraud, their case is not only more complicated, but it's hard to sometimes break the truth to them, and go through their case and say, this person took advantage of you. So that's something that we're really trying to track as much as we can, because it's a big problem, especially in this environment of a lot of fear and anxiety. There's a lot of resources. This was a very, very quick explanation of some of the things that we're seeing in immigration. There's a lot of resources out there if you'd like to learn more. TRAC has a lot of data about immigration court procedures, and the backlog is up to more than 1 million cases at this point in time, of people who are in removal proceedings and are waiting for their case to move forward. The Migration Policy Institute has a lot of information about numbers as well, and demographics here. The ILRC and NILC and NIJC and IAN are all national nonprofits focused on immigration resources. And then oftentimes, USCIS or EOIR has a lot of data that's published as well, and explaining a lot of their policy memos are listed on their website as well. So if any of you would like to learn more, this is kind of a starting point of being able to investigate a little bit more. So I've been talking a long time. Does anybody have any questions? Anything that I went through and maybe they didn't understand, or they'd like to learn more about, or something that I didn't mention but that they've been hearing about?
Hello, hi, nice to meet you. I came in a little late, but when you were talking about DACA being terminated, you said that the Supreme Court is going to have a hearing on November 12th. What exactly, what's the question that's going to be answered?
Great, yeah, that's a great question. So essentially the litigation was to say that the way DACA was terminated was incorrect. I think the main crux of it is that it was a violation of the Administrative Procedure Act. They didn't go through the proper channels, they didn't go through the proper procedures before they decided to terminate the DACA status. So that's essentially what the Supreme Court will be hearing arguments on. And there's also a lot of concern too on more of an equitable side of things, that this was, people kind of came, they were under the radar previously. They shared their information, they shared where they were living, they shared their history about themselves with the government, under the impression that they would be granted this temporary status. So there's a lot of concern too that people were kind of dependent on that. They built lives here, they got jobs here, they shared their information willingly. And if that's terminated, then how will that information be shared, and what kind of limbo that places them in?
Okay, so my question is, so I watched this show on TLC that I'm really into. It's called 90 Day Fiancé.
Okay.
And I just want to know because this woman was trying to get her husband over from Syria, and they said that he couldn't come because Syria is in a war zone, and that they would just deny his visa. So my question is, why do they deny visas from countries that are in war zones?
So with Syria in particular, that is a country right now where people have temporary protected status if they were here before the war broke out. My guess is, I can't say for sure because I need to know a little bit more about the specific details, but my guess is that there's a problem with the background check. If there's a lot of conflict going on right now in Syria, a lot of records have been lost. Is this person maybe involved in some rebel group or ISIS or other terrorist organization? That's just kind of a guess, is that they wouldn't be able to complete the background check and clear him to be able to come into the United States. There may also be the issue of the travel ban. I don't remember, since my organization and my program in particularly, we focus on representation of people who are already here in the United States, so I don't know as much about the travel ban and who that affects, but there may also be an issue with that as well, that there's kind of a blanket ban and you'd need to apply for a waiver to be allowed to come into the United States if you're from specific countries.
Thank you.
You're welcome.
I have a couple of questions we received via email for students that couldn't participate prior to the presentation. And one is, have you noticed, because you said during the presentation about the criminal relief, like the U visa and BAWA and all of that, have you guys seen less reporting, like that maybe people are, number one, that people don't know that this exists, that this type of relief exists for them, and also that people now are afraid to report domestic violence or report sexual abuse, physical abuse because of
Right.
the administration?
That's an ongoing issue, and that was an issue even before the Trump administration as well. And that was why the U visa was created. It was this intent by Congress recognizing this disconnect and this lack of trust between law enforcement and immigrant communities in particular. The U visa then was intended to try to build that trust. The police are there to protect you regardless of your status. If you're a victim of a crime, it's the police's duty to protect you as a community member. So as a way to kind of try and build that trust, it was a way to make people safer, make people feel more comfortable and safer in reporting those crimes. So that was an ongoing issue before the U visa created. The U visa was created to try to address that, and it's something that has never entirely gone away. But yes, we are. I think overall, I've always seen people who have confided in me and say, I was a victim of this crime, and I would follow up, did you report that to the police? And they say no. It's hard to track exactly one way or another because they go unreported then. But I think it's a logical thought process to then say, again, because of a lot of the anxiety and confusion out there, I think it's logical to say that then people are a little bit more concerned to report to the police because, again, they may be concerned that the police would then be arresting them or placing them on the radar with immigration authorities. Sure.
Thanks so much for being here. Can you just speak a little bit about the Cuban issue right now in terms of, I know there's been a bit of an uptick in folks getting deported to Cuba. What are you seeing sort of on the ground?
It's very confusing. Wet foot, dry foot, that previous policy that said if a Cuban came to the United States and was able to set foot on the ground here in the United States, they would be granted parole. That was rolled back many years ago. I think that may have even been rolled back under the Obama administration, but don't quote me on that. I could be wrong. So that's created a lot of concern then too, because Cubans have this ability to adjust under the Cuban Adjustment Act. It's only something that is available to Cubans, again, kind of recognizing the amount of people that we see here and the current situation in Cuba, but that requires a lawful entry. That requires that they came in on a visa, that requires that they came in on parole. So our confusion with the rollback of that policy, and then also it's kind of discretionary then when they come into the United States, whether or not they're granted parole, it's creating another class of people who, but for their not being granted parole, they would have been eligible to adjust status and potentially become U.S. citizens and fully functioning, able to exercise all of their rights as a citizen in the United States. So that's one of the things that we're seeing a lot and is concerning for us. But also there have been many people here who, for one reason or another, even if they've been here 30, 40 years, maybe have a criminal conviction or something, or again, maybe lack of parole, that have a final order of removal, but that hasn't actually been enforced. So they've been here in the United States, they've been checking in with ICE, usually annually, and because of the lack of a diplomatic relationship with Cuba and because of the current situation there, they were able to stay here and get work permits and become, members of society and have jobs and have businesses and whatnot. But now with some of the changes, we're actually seeing that people are being removed in certain circumstances, which is a big change in policy, something that we weren't seeing before. So I think, oddly enough, though, I know there's been something in the news too about some of the openness that began under the Obama administration in terms of being able to visit Cuba and whatnot. A lot of that has been rolled back too. But at the same time, we are also seeing that some Cubans in certain circumstances are being removed to Cuba. And then they're in the same situation where, new entries are coming in and having to go through the asylum process where previously they may have been able to become residents under a law that was specifically meant for Cubans. I don't know if that fully addresses your question or if there's a follow-up that you wanted to make. No? Okay.
Here, you were talking about meats, and I know, for example, okay, so we have this shelter for children, and then the word detention center was thrown around, pictures were in the media about the conditions, but coming from social services and working closely with like agencies like yours, we often relied on those shelters in order for us to provide services, but all of a sudden the light that is given at these is that these places are all evil and all of that. What's your take?
That's a good question. I mean, we kind of see both sides of that as well. With Homestead, it was open, it was a large shelter. We were able to contract and get attorneys in there sometimes to provide Know Your Rights presentation, to help find sponsors or to represent them in their removal proceedings or apply for some kind of relief. But at the same time, there was a lot of concern about other lack of access. I think the local Department of Education wasn't able to come in and provide schooling. It was done by the shelter, the detention center itself. So there's kind of two sides to the coin. If people are going to be detained there, then you want to make sure that they're safe, that they're comfortable, that they're being given classes, and that they have access to representation and whatnot. But if the shelter's shut down, then they also do kind of scatter, and it's maybe harder to track where they're going, and maybe harder to get some of the services that they had at the local facility. It's kind of a double-edged sword in a sense. Yeah. Sure.
Well, thank you so much for being here, and thank you guys for being here. This was great, and you clarified a lot of questions. And again, thank you so much for taking the time because we know how busy you and your colleagues are.
Of course. No, thank you for the invitation, and thank you for paying such close attention. I appreciate it.